Welcome back to the SafeSimpleSound podcast. This is the space where we slow down to speed up, using principles to build financial lives that are resilient, clear, and grounded. Today, we are talking about your last will and testament, but specifically, we are talking about the maintenance of that document. This episode draws directly from our recent blog post titled, Your Will Isn't Set It and Forget It, which you can find on our website. We're expanding on that written framework today because we've observed a specific pattern in our practice. Here's the challenge. Many families treat creating a will like a graduation ceremony. It feels like a massive accomplishment, and it is. But once it is done, they file the document away in a safe or a drawer, and they mentally check that box forever. They think, I have a will, I am protected, I am done. But from a safe, simple sound perspective, this view creates a hidden vulnerability. Life is dynamic. Your family changes, your assets change, the laws change. A static document in a dynamic world creates friction. So, whether you are a young family who just drafted your first will, or you are approaching retirement with documents that haven't been reviewed in a decade, this episode is designed to give you clarity. We are going to explore the concept of the living estate plan. By the end of our time together, you will understand the 7 specific life triggers that signal it's time for a review. You will understand the difference between a minor tweak, called a codicil, and a full update. And you will see how keeping your plan current is actually an act of love and stewardship. Let's begin by establishing the foundation of a current will. To understand why updating your will is so critical, we first need to look at the S3 framework: safe, simple, and sound. When we talk about being safe, we are talking about emotional and psychological safety for your beneficiaries. An outdated will creates confusion. Confusion breeds conflict, and conflict is the opposite of safety. When we talk about simple, we want the administration of your estate to be a smooth process. An old will that references assets you no longer own, or people who are no longer in your life, creates complexity. It forces your family to navigate a maze rather than walk a straight path. And when we talk about sound, we are looking for legal durability. Does this document actually stand up to the current reality of your life and the law? In our practice, drawing from our CSCFC background, we view an estate plan not as a stone monument, but as a snapshot. Imagine a photograph of your family taken 10 years ago. It's a beautiful photo. It was accurate the moment it was taken. But if you tried to use that photo today to identify everyone in your house, it might be missing a new child. It might show a spouse with a different hair color, or perhaps it includes people who have since moved away. The photo isn't bad, it's just obsolete. A will works the same way. The biggest risk you face after creating a will isn't necessarily a legal error in the drafting, it is simply the passage of time. So how do we systematically manage this? Through our Safe, Simple, Sound methodology, we have identified 7 specific life events. We call these automatic triggers. These are the moments where you should pause and say, does my snapshot still match my reality? Let's walk through these 7 triggers together. Trigger number 1, marriage, divorce, or a new partnership. This is often the most obvious change, but it carries deep legal implications. When you get married, many states give your new spouse certain inheritance rights automatically, regardless of what an old will might say. This creates a contradiction, an ambiguity we want to avoid. Conversely, consider divorce. In many jurisdictions, a divorce automatically revokes gifts left to an ex-spouse. That sounds helpful, right? But here's the nuance. What about the ex-spouse's family? If you named your former brother-in-law as an executor because you trusted him, the divorce decree might not automatically remove him. Or perhaps you want your ex-spouse to receive something specific for the sake of the children. Only an updated will can clarify these intentions safely. Trigger number 2, the birth or adoption of a child or a grandchild. This is perhaps the most joyful trigger, but also the most critical from a safe perspective. If you have a minor child, your will is the only place where you can name a legal guardian. If you have a second child 3 years later and don't update the will, that second child might not be mentioned in the guardianship clause. Furthermore, we need to ensure the new family member is included in the financial distribution. We want to avoid a situation where one sibling is named and the other is accidentally disinherited simply because the paperwork wasn't updated. That is a situation that creates decades of emotional pain, something we can easily prevent with a simple review. Trigger number 3, the death of a key person. This is a harder topic to discuss, but it is essential for a sound plan. Your will involves a cast of characters. Beneficiaries, yes, but also executors, trustees, and guardians. If the person you named as your executor passes away before you do, your will has a vacancy. Without a named successor, the court will appoint someone. That court-appointed person may not be who you would have chosen. Updating your will ensures you retain control over who manages your legacy. Trigger number 4, a significant change in your financial situation. We often think of this in terms of loss, but it applies equally to gain. Did you sell a business? Did you receive an inheritance? Imagine your old will left a specific cash gift of $10,000 to a charity, assuming that was 10% of your estate. But if your estate grows significantly, that $10,000 might now be a negligible amount, and your charitable intent isn't being fully realized. Conversely, if your assets have decreased, specific cash gifts might deplete the estate, leaving nothing for the residual beneficiaries, often your spouse or children. A sound plan adjusts the distribution logic to match the current balance sheet. Trigger number 5, acquiring a major asset. Buying a vacation home, a rental property, or a business interest requires a fresh look. Why? Because specific assets often have specific debts attached to them, or they may require specific management instructions. If you buy a cabin in the mountains that you want to stay in the family for generations, your will needs to specify how that ownership is shared. Otherwise, it might be sold and the cash split, which destroys the legacy asset you intended to create. Trigger number 6, moving to a different state or country. This is a purely sound legal principle. Estate laws are determined at the state level in the U.S. A will that was perfectly valid and sound in California might have complications in Florida. Different states have different requirements for witnesses, for spousal shares, and for executor qualifications. For example, some states require an executor to be a resident of that state or a close relative. If your executor is a friend from your old state, they might be disqualified from serving in your new state. When you move your furniture, you should also move your estate plan's jurisdiction. Trigger number 7, a change in relationships. Finally, we must acknowledge that relationships evolve. You may have become estranged from a beneficiary named in your will years ago. Or, hopefully, you may have reconciled with a family member you previously excluded. Or perhaps it's not about conflict. Perhaps your sister was the perfect choice for guardian when she was 30, but now she is 60, perhaps dealing with her own health issues, and naming her as guardian for a toddler is no longer the safe or practical choice. These 7 triggers, relationship status, children, death of a key person, financial shifts, asset acquisition, relocation, and relational changes, are your dashboard lights. When one lights up, it's time to pull the plan out of the drawer. Now, identifying the trigger is the first step, but knowing how to apply the fix is where we see the value of the SafeSimpleSound framework. To illustrate how this works in practice, and to demonstrate the difference between a patch and a repair, let me share a hypothetical scenario with you. Please keep in mind, the following story is entirely fictional. It is created solely for educational purposes to demonstrate how principles apply to estate planning. While the characters, let's call them the Harrison family, are not real, the patterns they experience are ones we observe frequently in our practice. Meet Mark and Sarah Harrison. Let's imagine that 10 years ago, when Mark and Sarah were 28 years old, they did everything right. They lived in Ohio. They had just bought their first starter home and had their first baby, a son named Leo. Because they were responsible, they worked with an attorney to draft a will. It was a sound document. It left everything to each other, and if they both passed, it established a trust for Leo. It named Sarah's mother, who lived 10 minutes away in Ohio, as the guardian and the executor. Safe. Now let's fast forward 10 years. The Harrisons are now 38. Life has been good to them, but it is different. First, they moved. They relocated from Ohio to Texas for Mark's job. Second, their family grew. They now have a daughter, Mia, who is 5 years old. Third, their financial picture changed. Sarah started a consulting business that has become quite valuable. And fourth, sadly, Sarah's mother, the named guardian, has developed significant health issues and can no longer travel or manage complex tasks. One evening, Mark and Sarah are looking at their old documents and realize the disconnect. If something happened to them today, under that 10-year-old will, one Mia, their daughter, is not mentioned by name. While laws often try to protect omitted children, it creates a legal hurdle, a complexity that requires court interpretation. That is not simple. 2. The named guardian is Sarah's mother in Ohio, but Sarah's mother is physically unable to care for 2 children, and the children have built a life in Texas. This creates a safety gap for the children. 3. The executor is also Sarah's mother. Navigating Texas probate court from a hospital bed in Ohio is functionally impossible. 4. The will doesn't account for Sarah's business. Without specific instructions, the business might have to be liquidated quickly to pay bills, destroying its value. While the Harrisons are fictional, this situation is incredibly common. Their snapshot from age 28 no longer matches the movie of their life at age 38. So how do they fix this using the S3 framework? They have 2 main options, and this brings us to the technical application of our topic today. Option 1, the Codicil. The first tool is called a Codicil. Think of a codicil like a patch on a pair of jeans. It is a separate legal document that says, keep the old will, but change this one specific sentence. If the Harrisons only needed to change their executor from Sarah's mom to Mark's brother, a codicil might work. It's an amendment. It must be signed and witnessed with the same formalities as a will. However, in our SafeSimpleSound approach, we urge caution with codicils. Imagine having a will, and then 3 or 4 different patch documents attached to it over the years. It becomes messy. It creates confusion about which version is the real version. It increases the risk that a page gets lost. It is not simple. Option 2, revocation and a new will. For the Harrisons, because they have moved states, added a child, and need to change guardians, a patch isn't enough. They need a new pair of jeans. The cleanest, soundest approach is to start fresh. This involves formally revoking the old will. When the Harrisons draft their new Texas will, the very first paragraph will likely contain language that says, I hereby revoke all prior wills and codicils made by me. This is a powerful sentence. It acts like a reset button. It legally invalidates the old Ohio document entirely. There's no confusion about which rule applies. The old snapshot is shredded, the new snapshot is framed. In their new will, they can name a local guardian in Texas who knows the kids. Safe. Include Mia explicitly in the trust provisions. Fair sound. Add a provision for the management of Sarah's business. Sound. Ensure the document complies with Texas law. Sound. Now, there is one more element the Harrisons can add to make this truly safe for their family. It's a concept we love at SafeSimpleSound called the side letter of instruction. While the will is a legal hammer, the side letter is a personal handshake. It is not legally binding in the same way, but it is morally persuasive and incredibly helpful. In our hypothetical, Sarah Harrison has a vintage jewelry collection that isn't worth millions, but has immense sentimental value. She wants specific pieces to go to specific nieces. Putting every single ring and necklace into the formal will can be tedious and expensive if she changes her mind later. Instead, she writes a side letter or letter of personal intent. She writes, to my executor, here is how I would like my personal items distributed. She lists the jewelry. She also writes down instructions for her funeral. She wants a celebration, not a mournful service. She writes down the password to her laptop and the location of the safe key. This letter provides the emotional and practical roadmap that the formal will does not. It removes the burden of guessing from the grieving family. It is the ultimate act of safe planning, providing clarity in a time of chaos. Through this fictional example of the Harrisons, we can see the pattern. They didn't just update a document, they updated their stewardship. They moved from a plan that was dangerous and obsolete to a plan that was safe, simple, and sound. Whether you are facing a cross-country move like the Harrisons or simply the quiet passage of time, the principle remains. Your plan must live where you live. As we begin to wrap up today's episode, let's bring this back to your kitchen table. We have covered a lot of ground. We established that a will is a living component of your financial life, not a static artifact. We identified the 7 triggers: marriage, divorce, births, deaths, financial shifts, new assets, moving, and relationship changes. And we looked at the mechanisms of repair: the codicil for minor tweaks, and the full revocation and new will for significant life pivots. From a Safe Simple Sound perspective, our encouragement to you is this: don't let the fear of complexity stop you from reviewing your plan. The discomfort of reading an old will is far less than the pain of leaving an invalid one behind. Here is your simple next step. Sometime this week, go find your estate documents. Just locate them. Look at the date on the signature page. If that date is more than 5 years ago, or if any of the 7 triggers we discussed have occurred since that date, it is time for a review. Read through the names. Are these still the people you trust to raise your children or manage your money? If the answer is no, or even I'm not sure, you have identified an opportunity to increase the safety and soundness of your plan. This episode draws from our recent blog post, Your Will Isn't Set It and Forget It, which contains a written summary of these points. You can find that at SafeSimpleSound.com. Through our practice's development of the S3 framework, we have helped many families navigate these exact transitions. We understand that updating a will forces you to think about difficult things: mortality, money, and family dynamics. If today's insights resonate with your family's situation, and you feel you need a partner to help you think through the financial implications of your estate plan before you head to the attorney's office, we invite you to explore what financial planning looks like through our Safe Simple Sound practice. We can help you perform that comprehensive financial review to ensure your assets align with your legal documents. But whether you choose to engage with our practice or not, please take this knowledge with you. You are now equipped with the capability to look at your estate plan not as a chore, but as a dynamic tool for protecting the people you love. Thank you for listening to the Safe Simple Sound podcast. Here is to building a future that is not just wealthy, but safe, simple, and sound.